Hey everyone, so today we're going to dive into a topic that I know most of us would really rather put off, but I want you to try and think about it a little differently. Not as some morbid plan for the future, but as one of the most practical, lasting acts of love you can do for the people you care about. And it all starts with one single question.
This question. This is the heart of our entire conversation today. It's a question that one local attorney and parent, Pooja Arora, lives with every single day. And honestly, her journey to answer it for her own family, well, that's what brings us here.
So this is Pooja and her son Ishaan. He's a teenager with severe autism and a pretty complex medical history. Ishaan is nonverbal and will need full-time care for his entire life. For years, Pooja's world, her whole life, revolved around being his primary caregiver, a journey that she says required everything she had. Emotionally, physically, professionally, just everything.
And this is where her personal crisis became a professional calling. You see, after Ishaan's needs grew beyond what the local school system could handle, Pooja had to make this absolutely gut-wrenching decision for him to attend a residential program. But she channeled that experience, that grief, into something powerful. She went back to law school, focused on estate planning, and eventually founded her own firm to help other families answer that same haunting question she lives with.
So Pooja's story, that gives us our why. It's the emotional anchor for this entire topic, because the question she carries for Ishaan is really just a version of a question that every single one of us carries for our own families. And the answer to that question is a plan. And a plan, when it's done right, is truly an act of love. All right, now that we get what's at stake, here's our game plan. We've talked about that guiding question. Next up, we're going to define what estate planning really is. Then we'll break down the 5 core documents, uncover a hidden weakness in almost every plan, walk through 5 big mistakes to avoid, and finally, show you exactly how you can get started today.
Okay, let's just clear up the biggest myth out there right now. Estate planning is not just for the super rich. It's not just about money. And it's definitely not just about what happens after you're gone. It's for every single adult, period.
You know, when you boil it all down, estate planning is just a set of legal documents that answer these 3 critical questions. What happens if I get sick or hurt and can't make decisions for myself? What happens to all my stuff when I die? And who takes care of the people who depend on me? That's it. Just 3 questions that every single adult needs to answer.
And here's the kicker. If you don't write down your own answers, the government will. Seriously. Every state has these default rules. They're called intestacy laws. And these laws will decide who gets your stuff, who raises your kids, who makes medical decisions for you. And trust me, the state's default plan probably looks nothing like what you would actually want.
So how do you provide your own answers? Well, you use a handful of key documents. Think of it like a toolkit for protecting your family. Let's open it up and look at the 5 tools that form the backbone of pretty much every estate plan. Okay, here they are. The last will and testament, a revocable living trust, a durable power of attorney for your finances, a healthcare power of attorney, and a living will. Now, don't worry, you might not need all 5, but it's really important to understand what each one does. First step, the will. We've all heard of this one, right? It has 3 main jobs. It says who gets your property, it names a person, an executor, to carry out your instructions, and for parents, this is the big one. It names a guardian for your minor children. Without this, a judge who has never met you or your kids decides who raises them. Just let that sink in for a minute. Next is the Revocable Living Trust. The easiest way to think about this is like a legal container, like a box. You create the box, you put your assets, your house, your bank accounts inside it, and you still control everything. The real magic happens in 2 situations. First, if you become incapacitated, someone you chose can step in and manage things for you without having to go to court. And second, when you die, everything in the trust passes to your family privately, avoiding that public, expensive, and really time-consuming court process called probate. And this chart just lays it out so clearly. A will, it goes through probate and becomes a public record. A trust avoids probate and stays private. A trust can manage your affairs if you're incapacitated. A will can't do that. But look at that last line. It's super important. You still need a will to name a guardian for your kids. So a lot of the time, they actually work together as a team. Okay, so the other 3 documents, these are all about planning for incapacity. The what if I'm still alive but I can't make decisions plan. The durable power of attorney for finances lets someone you trust pay your bills. The healthcare power of attorney lets someone you trust make medical decisions. And the living will, that states your wishes on things like life support, taking that impossible burden off your family's shoulders. Okay, so you did it. You've got your will, your trust, you're all set, right?
Well, not so fast. There's a hidden weakness in most plans, a simple piece of paper that can accidentally blow up everything you just worked so hard to create. I'm going to say that again, because this might be the single most important thing you hear today. The beneficiary designation on an account overrides your will. That little form you filled out years ago when you opened your 401k or got a life insurance policy, it's more powerful than your will or your trust for that specific account. So here's your homework. As soon as this is over, I want you to pull up the beneficiary forms for every single one of these accounts. Your retirement plans, your life insurance, even some bank and brokerage accounts. If you got divorced 10 years ago and your ex-spouse is still listed as the beneficiary, guess what? They get the money. It doesn't matter what your brand new will says. So please, check them. Update them. Now. All right, now that we know about that hidden weakness, let's cover the 5 most common and costly mistakes people make. If you can avoid these 5 things, you will be ahead of 90% of the population, I promise. The biggest mistake by far is just not doing it. Procrastination. We put it off because it's uncomfortable, I get it, but the cost of that delay doesn't fall on you. It falls on the people you love the most, who are left to clean up a legal and financial mess at the exact same time they're grieving. Mistake number 2 is trying to use a cheap, one-size-fits-all online form for a life that isn't simple. If you have a blended family or a child with special needs like Ishaan, or a small business, or really anything even slightly complex, a generic template can be an absolute disaster. It doesn't know what it doesn't know, and that can cost your family so much down the road. An estate plan is not a set it and forget it kind of thing. Life happens. You get married, you get divorced, they have kids, people named in your plan pass away. An outdated plan can actually be worse than having no plan at all. You've got to look at it every 3 to 5 years or after any major life event. Ugh, this one is just heartbreaking because it's so easy to avoid. People will pay an attorney to create this beautiful, comprehensive trust, and then they never actually move their assets into it. An unfunded trust is just a useless stack of paper. You have to retitle your house, your non-retirement accounts, into the name of the trust for it to work. It's like building a car and never putting gas in it. Please don't skip this step. And finally, mistake number 5, secrecy. Your perfect plan is totally useless if your family can't find it when they need it. So, tell your executor where the documents are. Tell your healthcare agent that you've named them. And please, please talk to the people you've named as guardians for your children to make sure they are willing and able to take on that incredible responsibility. Okay, we've talked about a lot of problems. Let's pivot to the solution. I know this can feel totally overwhelming, but it doesn't have to be. Let's just break it down into a few simple steps you can take starting today. Here it is, your recipe for getting this done. 1. Make a simple list of what you own and what you owe. 2. List out the key people in your life for each important role. 3. Think through some of those tough what-if questions. 4. Find a professional who actually specializes in this area to help you. And 5. Finish the job. Sign the papers, fund the trust, and have those important conversations with your people. You know, we started this whole conversation with Pooja's story, a story that was born from a parent's deep love and fear for her son. And that's where we end, because this whole process, it's not really about documents or taxes or courtrooms. It's about taking care of your people. It's about making sure the life you've worked so hard to build is protected. It is one of the most profound acts of love you will ever undertake. So if you're ready to start, but you just don't know where to turn, this is what Pooja Arora does at My Special Legal Planning. She helps families create plans that actually work when you need them to. She lived the stress and the confusion, and she built her practice to be the exact opposite: clear, patient, and incredibly thorough. You can actually schedule a free initial consultation on her website just to start the conversation. Thank you so much for spending this time with me today. If this was helpful, maybe share it with someone you love. And then I want you to do one thing this week, just one. Check one beneficiary form. Write down that list of your assets. Have one of these hard conversations. Just start. Take care of each other.